Welcome. Greetings from the SPJ headquarters in Indianapolis, Indiana. My name is John Schertzer. I'm the Executive Director for SPJ, and I'm joined by an outstanding panel to discuss today's issue, who I will introduce in just a moment. The webinar we're going to feature today is Censorship, Getting Past Reporting Roadblocks in the Time of COVID-19. Just a few notes about the course of our webinar today. You'll notice on our Zoom feature here, there's a Q&A button. Please use that if you want to give any questions to the panelists. I will try to sort through those as we go through the presentation portion so that we're ready to have those as we get to the question and answer time. You can also use the chat feature. You can also put questions there, but what I encourage you to do is use the chat feature to discuss these issues with each other, to react to things that are being shared, and also to share any resources that you are aware of that would help all of us understand this issue even better. So we're going to go for about an hour, and we hope that you are here and to learn and to ask questions as we get into this issue that is of very major importance to the world of journalism today. I'm pleased to be joined by a fantastic panel. I'm going to give a quick intro to each of them, and then we're going to start with our presentations as we go through the content this afternoon. First, I'd like to introduce Paul Fletcher. He is the chair of the SPJ Freedom of Information Committee. He served as SPJ's national president in 2015 and 2016. He is the publisher and editor-in-chief of Virginia Lawyers Weekly. This month, he celebrates 32 years of work with that newspaper. He has won numerous state and national journalism awards, including honors for editorial writing, column writing, and features. Paul is the president of the Virginia Press Foundation Board, serves on the boards of the SPJ Foundation and the Virginia Coalition for Open Government. We're also joined by Kathryn Foxhall, who has covered health in Washington for 40 years, including 14 years as an editor of the American Public Health Association's newspaper. After years of getting a dynamic education by speaking frankly with sources on Capitol Hill and in agencies, she became alarmed when 20 to 25 years ago, federal workers gradually came under rules banning them from contact with journalists without reporting to the authorities, often public relations offices, heavy censorship that she felt coming down from people in power, and hence one of the reasons she's such an advocate for this issue today and here on our panel with us. And then lastly, Frank LoMonte teaches media law at the University of Florida, where he directs the Brechner Center for Freedom of Information. The Brechner Center is a think tank dedicated to research and advocacy in support of journalists' right of access to information. Frank has been a practicing attorney for 20 years after a career in journalism, and previously was director of the nonprofit Student Press Law Center based in Washington, D.C. Since 2018, he has served as a board member of the SPJ Foundation. Again, we're very pleased to have these three experts join us today. We're going to start with Paul Fletcher, who has some information to set the table and share his perspectives on this issue.
Thanks, John, and thanks everybody for being here today. These are some very important issues that we are going to be talking about. And this is a program about roadblocks. That's one of the words that we fairly carefully selected to put into the title of this program. Roadblocks to reporting in the time of COVID-19. Think about the types of things that are getting in the way of getting stories. You have stay-at-home and lockdown orders. While I think in probably just about every state, the media is going to be considered an essential business and that we can come and go, it does make it harder to get hold of sources. You might have to track them at home. You might have to use home phone numbers. It's not as easy as picking up the phone and calling somebody at an office. If you cover legal matters like my newspaper does, the courts have been closed. And so that it's harder to get information from courts, you have to get creative. For example, if you want either the complaint or an answer in a lawsuit, usually you might be able to just go down to a courthouse to pick up a copy. Now you might have to call counsel if they're willing to give it to you. One of the things we may not think of as a roadblock necessarily, but the fact that the emergency is hitting the newspaper industry very hard. We have seen layoffs, we have seen furloughs, we've seen pay reductions, all kinds of problems. And if there are fewer people who are out there covering stories, that makes it more difficult as well. And then there are the PIOs, the public information officers. And we're going to be talking at length about them this afternoon. I know Kathryn has been the top authority within SPJ fighting this particular issue and problem. And that's where the censorship part of our title comes from. Because you may have PIOs or government officers or elected officials who are taking the opportunity to shut down press coverage. And it's made me wonder if they have thought about Rahm Emanuel's famous quote, you should never let a good crisis go to waste. So one of the things that's in Kathryn's materials, which will be available by email or on the SPJ website, there's a question in an FAQ at the Centers for Disease Control that kind of sums up the issue. Why is it necessary to go through a press officer when I want to talk with a CDC expert? Pretty straightforward question, right? The answer that they give you in the FAQ is press officers are here to make sure your questions get answered by the best spokesperson for your story within your deadline. CDC experts are working scientists and may not be available for interviews. The last I looked, CDC experts are paid on the public dime and are public employees, and the information that they're putting together is public. And I think the first word in the title of a PIO, a public information officer, often is the one that gets overlooked or lost. Let me, I have some slides that I want to share, so let me share my screen real quickly with you. Okay. This is our program. This is us here. One of the things to think about, go back to the point I made a minute ago about the fact that newspapers have been laying off or furloughing employees. These are some statistics from 2018. PR professionals outnumber journalists 6-1. This, as I said, this is 2018. That's a 2 times increase within 10 years, according to Muckrack. And according to some numbers that I got from the Bureau of Labor Statistics, the demand for public information officers is expected to grow by 7% in the 10 years between 2014 and 2024. So in other words, there are more PIOs out there, and there are likely to be more PIOs than there are reporters or journalists to cover them. One of the things that I think is important in working with and understanding public information officers is you need to know where they're coming from. You need to have a sense of what their strategy might be. You have to understand that more than likely there is a party line within an agency that they will seek to hew to. I know I talked to one veteran Washington journalist who was at one of the agencies, and they made it very clear, this is what we are going to follow. Here's what they get taught with. This is called the Big Blue Book on Capitol Hill. It's a media relations handbook by Bradford Fitch with Jack Holtz, the editor. It's well known. It's used as a textbook in PR classes in and around the DC area. And it advocates a top-down messaging approach with tight control from an organization's PR team. In other words, they don't want just the average employee to be talking, which mirrors the quote that I gave you from the CDC FAQ. And here's some examples. One of the things that they had to say about when George Bush's people came in, and you'll note that time frame is important here. You'll note that in Kathryn's biography, she talked about 25 years ago was when things seemed to start to change. Okay, figure out who was president and which administration was in place then. It was the Clintons. and then followed by George Bush, W. Bush, followed by Barack Obama. Regardless of party, either Republican or Democrat, there have been problems that have continued. I recall yet another DC journalist who said, I remember a time, this was back during Bush 1, when you could pick up the phone and call a top person over at the FAA or one of the other agencies, that it really was quite open. Sometime in the mid-90s or so, and Kathryn can certainly share her story as somebody who was on the front line then, things started to change. After 9/11, things really changed. And this is what the book has to say about the Bush people. The key to the success was instilling a mentality or fear in the administration that information would flow only through approved channels. From the campaign into their installation in power, the Bush White House established a regimented communication policy. They built a wall that no leak could seep through. And I think one of the most interesting words that was used in this quotation is the word fear. Because if you look at the current administration, clearly with the shutdown and information that has come from the top, it is very much fear-driven, I would think. More lines from this manual. And this is a general policy. It must be made clear to all staff that they should deal with the media only when authorized by the public relations team. And here's the kicker. Loss of control over communications can be a disaster for an organization, leading to public controversy and loss of credibility. The communications director, when the communications director is saying one thing to a reporter and another staff member is saying something different, the reporter will no doubt highlight that conflict for what it's worth, which is what we do. Obviously, when there is a difference, and they don't want to be written about. Or as one person here, one Capitol Hill chief of staff puts his office policy very succinctly to his non-press staff. If I ever read your name in the paper, it better be in the obituaries, or it will be. So very clearly, there is a design that comes from above. Well, then there's SPJ. As I was getting ready for this webinar, one of the things that I recall, because I know when I was on the leadership ladder, the PIO issue was one that we fought frequently. And in fact, for about the past 10 years, SPJ has been at the forefront of seeking to change some of the practices with public information officers, trying to get more transparency. And if you look at this page, the address is right there, spj.org/pios.asp. This is a great resource in terms of seeing what we've done and getting ideas on how to push back. And it gives you an idea of what SPJ has been doing over those last 10 years. Carolyn Carlson, who recently retired from Kennesaw State University, did 7 surveys that were sponsored by SPJ of different organizations and different types of reporter groups to get a sense of what was going on out in the field. And those are available in full right there. Over the course of about 4 or 5 years, SPJ routinely was the leader that gathered a number of other journalistic organizations. There are about 70, 75 in the country. And we would ask them to join statements that we made, letters that we put out. We wrote to the Obama administration a number of times. And as I'll show in a minute, we actually went and visited the White House during the Obama administration, trying to get some traction on this particular issue. And there are links to a number of other articles that you can read. on this particular issue. I would note that the two most recent letters that we sent on this issue, the first was one that was sent in January of 2017. Recall what happened in January of 2017. Donald Trump and Mike Pence took over as president and vice president. We gathered 30-some of our usual friends that join us in such matters and requested an opportunity to talk about press issues with the new administration. And so far as I know, that was totally ignored. More recently, last fall, at the San Antonio Convention, we passed a unanimous resolution seeking to support a federal bill that ultimately did not pass. But we sent a letter to a number of members of Congress, and we actually got some responses. So the issue is still out there, despite the fact that the president in his first press conference called out CNN as quote unquote fake news, which kind of has set the tone of press relations since. Here's what I mentioned. In December of 2015, 6 people, and Kathryn and I were fortunate enough to be 2 of the 6, who went, it was a group led by SPJ. It included representatives from the Society of Environmental Journalists and ASNE. We were there on behalf of 53 journalism groups to meet with Josh Earnest, the president's secretary at the time. And we made an ask for greater transparency, and we sought to discuss PIOs with Earnest. And here's what we got in return. This sounds, you'll note, this sounds very familiar to that FAQ on the CDC site. Earnest shared his view and told us what he thought they were supposed to do. They serve as a clearinghouse. Their role is to help with the flow of information to the reporter. And here's the money quote from it. It's not the job of a government employee to answer the questions from the reporter. That's the PIO's job, he said. He promised us a dialogue, and we kept after it, really for the rest of 2016, trying to get some kind of response. And frankly, we're still waiting for it. And here's an opportunity, if you ever wonder if you should eat some words that you've put out there. This is a press release that we put out in September of 2016. And it quotes me. We've made multiple attempts to convey to the Obama administration that we believe transparency has in fact gotten worse in the past 8 years. We were hoping we could point to this White House as a shining example of how it should be done. Unfortunately, we can't do that, and now we'll have to start over again with the next administration. So how did that work out for us, huh? So, and with that, I will pass the baton to Kathryn.
Okay, thank you all for joining us. I am alarmist to the point that I feel like people are going to think I'm a conspiracy theorist, but so be it. I have seen this thing grow over a number of years, and to take right now as just a horrific example, it has become a cultural norm. Huge censorship over the whole country. I tend to talk about the federal establishment because I know a little something about it, and right now it's so important. But this is a monstrosity that is showing itself to be what it is right now. I covered public health for 17 years. I do not believe that we would be in as bad a shape as we are now if reporters had not been all but pushed out of the Centers for Disease Control and a number of other agencies. I reported for maybe 17 years before this thing started happening. Okay, I was reporting for public health professionals at the time that the HIV crisis began, when we knew that AIDS was out there. My go-to story is that I was talking to a scientist at the Centers for Disease Control, and he gave me the official story, and I was actually getting tired, and I said, "Doctor, is there something you could tell me if your name weren't attached to it?" Well, it was before the PIO institution of control over all communications, and nobody had any way of knowing that we were talking. Well, at that point, he exploded. And he told me hard facts on how things happened, on the lab crisis that was happening within the agency because of budget cuts, how it was impacted by the AIDS crisis, the fact that we were going to know less about the AIDS crisis because of the budget cuts. The thing is, if I was within 2 inches of writing the official story as he first told me. It would have been better had I never been born, had I written that story. It would have been true. It would have been well sourced. It probably would have been impressive. I was working hard on it. And it would have been just completely misleading to public health professionals. It would have been a horrible thing. And this is what I want journalists to be haunted by. I would not have known until this day what I had done. It is just essential that reporters be free to do their jobs, and that means talk to people confidentially. The thing that has happened to us, in case you have any questions about it, is censorship. And censorship is one of the top most rotting, debilitating things that can happen to any society. And right now we have a culture of intense censorship. The public health agencies on the federal level, just as an example, have successfully fended off public scrutiny that they didn't want. We can't walk into the buildings. We don't have credentials that would allow us to walk into the buildings. We cannot speak to anyone without a censor on us. The delays, even within that configuration, are beyond anything that are reasonable. It's a total barrier to actually reporting on any kind of a normal level. Reporting and actually inside reporting in FDA and CDC are down to almost nothing compared to what they should be and what they were previously. Okay, so why are these stories on the FDA and CDC coming out? For one thing, they're handouts often. They're either briefings, press releases, or meetings. They're controlled circumstances that allows the information to flow that the people in power want to flow. In reporting, we have this ethic that says a good reporter gets the story anyway. It's a good work ethic. It's also one of the most dangerous ideas in the nation today, because there are some excellent stories. There are stories that I would have just give anything to have written myself. Just real impressive. The problem is that it looks like we can report on CDC. In actuality, there are still 10,000 people in CDC that are silenced. And we don't know what that would do to the story that we have written. We don't know how many other stories they could give to us. Those fantastic reporters who have pulled over that 25-foot wall, a real impressive fish, would just have their socks knocked off if they could walk around CDC or call around CDC and talk to people normally without the censors. This is keeping information all the time from the public. It's also keeping information from the professional communities, doctors, the business organizations that develop the drugs, etc. It's extraordinarily dangerous. It's dangerous on the level of what China did to us with its secrecy. Why can't we, as a profession, journalism, face this? We're in charge of telling the public things that are dangerous to them. This is horrifically dangerous. This is a monstrosity sitting behind the walls of these agencies. Again, we do the thing about good reporters get the story anyway. And I think in reality, that is often whatever we get, which often we kill ourselves getting, is the story. The psychologist Daniel Kahneman says that there's a human bias that makes us believe whatever I see is all there is. And I think we as reporters don't want to think about those other 10,000 people at CDC and how quite possibly and probably there are things behind those walls that are going to kill people. I put my email on my bio, and one thing I really like to get out of this is to have people email me with their own thoughts and experiences.
Thank you, Kathryn. And now we'll ask Frank to share his perspectives on this issue.
Thank you so much, John, and thanks to everybody for joining us. And I should say it's incredibly valuable to have the perspective from people like Paul and Kathryn who have been doing this work in the trenches for decades, because one of the things that tells us is that this phenomenon of heavy-handed gatekeeping by government agencies getting between journalists and the subject matter experts is not a state of nature. It is not the way things have to be. It's not the way things must be. It's just the way things that we've grown accustomed to them being over the past couple of decades. I have my own reporting experiences prior to being a practicing attorney that go pre-9/11. I remember the days in Washington, D.C. when you could walk around federal agencies and plop down on good old Fred's couch with your notepad and ask good old Fred what he was working on and get yourself some stories that way. But those days are long gone now. As Kathryn so eloquently points out, we've got government appointed minders now who will walk you around that agency and escort you out the door as soon as your appointment is over with. And that stumble upon factor, that value of being able to unearth the deeper story has largely been lost because of heavy-handed government gatekeeping. So while my role here as the attorney is to talk about some of the legal strategies, arguments, and workarounds, we shouldn't lose sight of the fact that we've got both a legal issue here that I'll get to in a second, but also a cultural issue. And it's one that we should keep talking about in a sustained way, you know, something that as an advocate for open government working at the Brechner Center, it drives me crazy sometimes to read a news story where somewhere around the 12th paragraph, there'll be a throw in that says, well, of the 50 agencies that we FOIA'd, 20 of them them never answered our FOIA. And then the story just moves on. And I think to myself, well, wait, that's the lead of the story. The lead of the story is 40% of the government agencies didn't discharge the bare minimum legal responsibilities that the law imposes on them to be transparent. And I think lots of us have sort of gotten accustomed to, and newsrooms have gotten very, very young in the last few years, and people don't have that 30 or 40 years to draw on. Lots of us have gotten accustomed to this kind of PR culture that we're living in right now, this moment where it's just accepted with a shrug that, well, of course the government has a brand to protect. You'll hear that phrase a lot, brand, protecting the brand. Of course the government has a brand to protect, and of course they want to keep everyone on message. And when you hear that as a journalist, that should be nails on the chalkboard to you. That should be a gag reflex moment. The government is not Tide laundry detergent. The government doesn't have a brand to protect. They're a provider of public services, and their image is of no consequence to us, and it should be of no consequence in the land of the First Amendment that I'm here to talk about. So let me just share with you, I put together a brief presentation that kind of highlights some of the research that we've been doing at the Brechner Center. Brechner Center, by the way, and I'm delighted to hear from anybody who's got questions about their legal right of access. I took this job about 3 years ago, or I accepted it 3 years ago, and had a few months to transition. And so I started asking my friends in journalism and in law, I asked, well, what are your pain points? Tell me, if you had some legal tools at your disposal, you had some a legal skeleton key, what are the laws what are the things that you'd most like to unlock? What are your pain points? What are the things that are most getting between you and the information that you need? And almost unanimously, this issue about public affairs officers interposing themselves between journalists and the frontline subject matter experts rose right to the top of the list of complaints. And it was not just federal reporters by a long shot. It was people at all levels of journalism dealing with everything from the Pentagon down to the tiniest little local sheriff's office or school district. So this is a pervasive cultural problem, and one that I am here to tell you is not legal, and there are legal strategies to fight back against it. Paul mentioned the excellent research that Carolyn Carlson did under the auspices of SPJ while she was teaching at Kennesaw State, and I've just kind of distilled some of her findings here. I mean, what she found in surveying journalists who had different specializations was that everyone was experiencing some level of heavy-handed gatekeeping by public affairs officers, and some of them were experiencing it all or most of the time. As you see from her findings, right, it was very commonplace for 50% or greater of the journalists that she interviewed to say, yes, on the beat that I cover, I am required. I am unable to speak to those frontline subject matter experts that I need for my stories without going through a public information officer. And often, while good public information officers, and there are plenty of good ones, recognize that their job is to facilitate access and to introduce you and connect you to the best people and then get out of the way, oftentimes the journalists were reporting that they never got to that frontline subject matter expert, that they got handed off to somebody who was handpicked by the agency, probably somebody who was compliant with the agency's message and was not a dissenter or a troublemaker or a complainer, somebody who was going to toe the agency's party line, or they got handed a canned, written, typed up release with quotes on it that they were expected to treat as if they came out of the source's mouth. Well, you all know as journalists on this webinar that when you're dealing with, and particularly we're here in the context of a global pandemic, when you're dealing with something like a global pandemic, you don't want to hear from the hospital public relations office, this is the stress that our doctors are going through, or this is the fatigue that our nurses are feeling. You want to hear it from them. You want to look that nurse in the face. You want to get her on camera, and you want her to say, this is what the stress is doing to me. This is what the fear is doing to my family. There's no substitute for that. And so we can't accept being shunted off to a public affairs spokesperson in lieu of actually getting that firsthand subject matter expertise by the people working on the front lines. Think about some of the most memorable stories that you yourself have experienced during the COVID pandemic, and chances are it came out of the mouth of a doctor, a nurse, an EMT, maybe even a delivery driver, right? Somebody who is out there providing frontline services and putting their own safety at risk to do so. And that's why these gatekeeping policies are so toxic, because they interfere with the public's ability to hear at a time when people are just awash, right, in rumor, speculation, conspiracy theory. The antidote to conspiracy theory is what? Hard evidence. And to get that hard evidence, you need to hear from the people who are actually going through the experience. Well, so we know that there's a problem, and we know that it's especially pervasive in certain fields and certain industries, even though all government agencies do this. The Brechner Center in October of last year published a study on the Brechner.org website, and then followed that up with a law journal article in the Kansas Law Review. It was published in December of last year, where we looked at gag policies across all levels of government. We have another study coming out this summer that specifically focuses on college sports, college athletics, because in the public university setting, it is especially commonplace for universities to say no journalist is allowed to have contact with an athlete without a public affairs minder getting in between them. We don't think that's legal either, and our article coming out this summer will lay out why. Interestingly, when you examine some of these policies, some of them are directed to the employee, or in the case of college sports, to the athlete, but some of them too are directed to the journalist. And these raise different First Amendment issues. These are analytically comparable, but different things. If the retaliation, if the reprisal, if the impact of defiance falls on the employee, then that's one set of First Amendment issues, and we'll talk about that in a second. If the impact falls on the journalist, that's another set of First Amendment issues, a different set entirely, and a different analysis, right? Are we violating the rights of the journalists, or are we violating the rights of the employees? And interestingly enough, one would think probably that after 150 years of doing this, right, the federal courts that have a very robust body of case law that tells us that you can't punish journalists for going around public affairs officers to talk to their sources. I can't actually tell you that that body of case law exists. Journalists don't tend to bring those cases, but who does is government employees. We can say with a high degree of confidence, I mean, a slam dunk degree of confidence, that it is not legal for a public agency to maintain a policy that says employees will suffer some kind of retaliation or reprisal or punishment if they are caught talking to the news media without approval. It is just overwhelmingly the case that every federal court that has ever been asked this question has come down the same way, and it has been true for many, many decades. One of the headwaters of this First Amendment doctrine is a Supreme Court case called the Treasury Employees case. This was a case that involved a federal law that was supposed to be an anti-corruption statute that limited the ability of federal employees to give speeches to outside groups. The fear was that somehow these groups are going to bribe the employees with honorary and speaking fees and influence government policy. And the Supreme Court strikes this down in 1995 and says, no, this is a prior restraint. And those of you who studied any media law at all know that once something is a prior restraint, boom, it's unconstitutional. Go directly to jail, do not pass go. And so the prior restraint is struck down as unconstitutional. And ever since then, the courts have been unanimous that none of these gag policies, whether it's phrased as a policy or a rule or a handbook or a regulation, or it doesn't matter. You could call it a banana split. It doesn't matter. It is unconstitutional if an agency is telling its employees, you will suffer punishment if you speak to the news media. There was some case law back during sort of the early days of the Roberts courts that I think probably blurred the field a little bit and caused some people working in government agencies to feel empowered to crack down on government employees. There was a kind of an infamous case out of California called the Garcetti case that involved a guy punished for writing a memo that undermined a prosecution that the district attorney he worked for was pursuing. And the Garcetti case kind of stands for the proposition that, well, if you're assigned to write a memo and the boss tells you to write it a certain way, and you write it in the opposite way than the boss assigned you, you can't claim First Amendment protection for that if you get fired. And it's kind of an unremarkable case, really, but lots of employers kind of took that and ran with it and said, oh, well, the Supreme Court has now given me a license to punish my employees for anything that they say. And then in 2014, the Supreme Court kind of conclusively strikes that notion down in a case called the Lane case, where Justice Sotomayor writes that, no, just talking about information that you learn in the course of your job is not the same thing as doing the assignment wrong. And the Garcetti case was about doing the assignment wrong. But just because you're talking to the public about something that you learned in the course of your employment doesn't mean that you've lost your First Amendment protections. So this idea that seems really pervasive across government agencies, that somehow you check your free speech rights at the door when you take the government paycheck, that's just not the law. It's kind of like the speed limit. The fact that everybody is on the highway speeding doesn't mean it's legal. It just means that it's common. And I think government agencies are commonly under the impression that they have a lot more legal authority over their employees' speech than they do. And you can see here, we called out a couple of the 24 cases where employees have challenged this. A policy that says don't make unauthorized public statements or don't address things of a controversial nature. That's unconstitutional. Don't make official comments relating to department policy. That's unconstitutional. And I think one of the reasons why these policies are still so pervasive, despite the unanimous case law saying that they're unconstitutional, is that lots of these cases were brought 20, 30, 40 years ago. That was really the heyday of this employee First Amendment litigation at a time, frankly, when labor unions were much better funded and more powerful than they are today. Lots of the cases were brought on behalf of firefighters or police officers who had good counsel from their labor unions. And because labor unions don't have the funding and the staffing to pursue these anymore, and frankly, they have other priorities, they're working on pay and healthcare benefits instead, the litigation in that area has kind of subsided. So lots of people working in government public relations today, who just took the job 10 or 15 years ago, this is not within their experience and their understanding, right? This is not contemporaneous to them. So I think it's our job to remind them of their legal obligations. So what can we do about this? Now that we know this is against the law, now that we know that agencies are breaking the law, if they enforce these restrictions, what can we do about it? Well, there is a roadmap, and the report on the Brechner.org website explains news agencies and journalists have been able to step into the shoes of their sources and assert First Amendment complaints on their behalf. It happens all the time in the case of like a judge's gag order on the people participating in a trial, right? You're participating in a trial, you're a juror, you're an attorney, you're a witness. You're not going to sue the trial judge because you've been gagged from speaking to the media, right? What juror is going to do that? I'm going to get a lawyer and sue the judge? Hardly, right? And so it's the job of the journalist to step into the shoes of the gagged speakers and to say, well, we are here to assert the First Amendment rights of the people who are not in a position to assert their own rights. And the courts have unanimously recognized that, yes, journalists have what is called legal standing to bring these challenges. And so we certainly encourage news organizations and organizations like SPJ to be looking for what are the most blatantly unconstitutional gag policies out there, and let's find ways to take them on. The Knight Center at Columbia University seems to have the CDC in the crosshairs right now. They're suing them right now for access to the documents that would establish that CDC, in fact, has a gag policy, and I think that is a precursor to a First Amendment lawsuit if they document that, in fact, the gag policy exists. So just practical tip, and I need to wind down in a minute here and turn to questions, but practical tip, if you are that journalist and you are working with an agency where you're being told by the employees, nobody here is allowed to speak to the media, get that documented, track that down, run it to ground, and find out, well, is there really a formal policy here? And can I see the policy? And sometimes you find out that the policy doesn't really exist. This is just kind of water cooler conversation that has been handed down through word of mouth that if you get caught in the newspaper, you'll be on the boss's naughty list. And that's not the same thing as a policy, right? That's just an agency culture problem. But then it's important to publicize it, right? If you get an agency, and I've seen journalists do this, if you get an agency to go on the record and say, no, what are you talking about? We have no such policy here. Our employees are free to speak to the media. We would never punish anybody for giving an interview. Publicize the heck out of that. Let the employees know that their boss has just gone on the record as saying that they are free to speak to the media, and hang on to that the next time you're told that a quote unquote gag policy exists. Real quick, and we can go into this in the questions if you like, but kind of a little bonus law here. We came here to talk about government agencies, but you can't ignore the fact that lots of the worst silencing is going on in the private sector, not the public sector. There have been lots and lots of stories in recent weeks about people being threatened or even losing their jobs at hospitals or nursing homes, most of which are not government owned, right? Most of which are private corporate owned, being threatened with the loss of their jobs because they went public and talked about how they need better PPE, better protective equipment. And it turns out, to the great surprise of lots of people working in this field, that those types of don't talk to the media policies are regarded as an unlawful labor practice, even in the private sector. And there are many decades of case law from the National Labor Relations Board saying that if a private corporation, like an Amazon.com, which seems to be punishing its employees for speaking out about PPE, if a private corporation like an Amazon.com is maintaining and enforcing a policy that says nobody here is allowed to speak to the media without authorization, and if we catch you doing it, we'll fire you, that is an unfair labor practice. And employees can and do win reinstatement if they challenge it. And so be aware that now the NLRA is not as good as the First Amendment because it doesn't apply to certain managerial, supervisory level employees. It just applies to rank and file employees. And it doesn't apply to religious church institutions. And it doesn't apply to government agencies. So in the public sector, the First Amendment is the recourse. In the private sector, the NLRA is the recourse. But do be aware that this exists. Do be aware that there is some good legal authority out there that says that even in the private sector, one of these don't talk to the media and you'll be fired if you do policies, there's every chance that that is an unlawful policy and that employees can successfully challenge it. John, I'm going to stop there and see if there are any questions.
Great. Thanks you, all three of you, for setting the stage on that and for giving some great advice and thoughts around this issue in general. And Frank, you started us down the path of, so what do we do and how do we get through this when we confront it? So let me ask that to Paul and Kathryn as well. Is any specific tips or ideas for, and you might envision a young reporter out on their first assignment or on an early assignment in their career and getting some stonewalling. How do you fight through that? How do you, beyond, using some of the larger First Amendment issues or legal concerns of that Frank raises, in the moment, how do we get through that issue so we can get to the story?
Hey, Paul, you're on mute.
Sorry, I forgot I was muted. In the moment, we are messed up. You know, when you have a front page story, I mean, impressive front page story in the Washington Post, and it's breaking, I mean, it's the work that has gone into it is just amazing. And the reporter says the CDC will not allow them to talk to the people who were involved in the testing. I mean, this is the Washington Post and the CDC, who apparently is killing people with its incompetence, won't let the reporter talk to anyone who might say the wrong thing. We have a culture of people just telling us to go to jump off a cliff. That's just to tell anyone out there also that it's the big guys too. The big guys are being stopped by this, and they also get stories, but they also are leaving a lot of information behind. Right now, I began to talk to your agencies about the fact that this is illegal and immoral, and write about it. Write about it. If you can't be unbiased enough to do a story about it, do an editorial about it. Tell the public this could kill you, what we don't know. And we like to say, we like to present the image that we know everything, but it's time to tell the public that this is horrible censorship and it could kill us.
I think to answer your question, John, a young reporter starting out, say this is not somebody who's covering a government agency in DC, but is in a smaller newspaper in a smaller town, they're going to be dealing with this same person over and over again. So I would say being polite but persistent in seeking information. Use a FOIA request if you have to. I think Kathryn's point about writing about it is a great thing. We all have a megaphone that we can use if there's a problem getting information. Find a way to make it clear that you're not going away. You're going to find the information as best you can. But you do need to have a certain level of relationship with that person, because you're going to be seeing them over and over again. And if you just really spoil it, you'll never get any help from them.
John, if I can hit a couple of the questions that I see in the chat, let me just take down the ones that I can see right now, and then feel free to jump in and present some of the other ones. One question was, well, now that we know that these court decisions are out there, how can a journalist actually use them without having to bring their own lawsuit? And it's a great question, right? Because you got an agency that is convinced that they're acting legally, and undoubtedly they've been trained that this is, as Paul was showing, that this is a best practice, right? Well, what do you mean this is illegal? I went to PR school. I was told this was a best practice, and I'm just doing what I was trained. And I think the answer is a couple of fold. First of all, write about the existence of the gag policies. I think that's a standalone story rather than, my example of the paragraph 12 mention of the people not answering the FOIAs, right? Do the standalone story about the fact that, hey, in Oregon, 15 out of 20 sheriff's agencies that we surveyed all have policies that say nobody here can talk to the news media, even though we're in the Ninth Circuit and the federal Ninth Circuit has said that these policies are unconstitutional, right? And I think sometimes you just got to call people out frontally on it and say, well, look, here's the court ruling. Courts have said this isn't legal. I put my email already in the chat, and I'm happy to give you a soundbite that says it's not legal. I think you should just got to call them out frontally on it and say, okay, well, now what are you going to do about this? Now that you have been shown that there's a court ruling that said this is not legal, are you going to do anything about it? And so I think frontally attacking it is a big thing. And right, as Paul was saying, you use the power of the editorial page too. If you can't do it in the news pages, do it in the editorial page. Somebody asked too, well, what if it's not really a quote unquote policy, but it's just in the training that employees get, which is very much, it's quite commonplace that's where the message is conveyed. It's not really in a quote rule, but it's in some PowerPoint that was shown during their onboarding. And so my first answer to that is get the PowerPoint. We've seen journalists often do good stories when they get a hold of the training materials that people are being given, and the training materials are somehow deficient. And so get a hold of those training materials, and again, run them by, whether it's me, whether it's somebody with SPJ, run them by a First Amendment expert, head of your state press association, counsel for your state press association, and say, look, does this training hold up to First Amendment standards? Are people being trained to break the law here? And so, yeah, get a hold of those training materials. And again, you got to call them out.
Also, if you want to describe the particular situation to me or to someone else at SBJ and have us give you a quote that this is just a horrible, un-American, something just to hit your audience, we're here. We'll give it to you.
Oh, somebody asked too, I just finished writing a little blurb about this for our own newsletter. Somebody asked about HIPAA or privacy concerns being used to deny them access to information about the location of where COVID cases are taking place. So first of all, the questioner asks, well, what if the agency is citing quote unquote worker privacy? Well, there is no such thing as a worker privacy exemption to public records laws. That just isn't a thing. There are many states that have an exemption that is called the clearly unwarranted invasion of personal privacy exemption, but that's a pretty narrow exemption. And certainly if all you're asking for is, look, I want to know if particular workplaces in my county or in my coverage area have reported positive tests, as long as it's not a mom and pop store with 3 people working in it, right? If it's a mom and pop store with 3 people working in it, you're not going to get that level of granular information. They may have an argument that, look, we say there's 2 cases in a 3-person workplace. We've just outed the people who have COVID. But if it's not that, if it's a factory, if it's a meatpacking plant, then of course saying there were 2 cases or 3 cases or 30 cases doesn't name any individuals. And all the HIPAA or the state equivalent of HIPAA is concerned about is the information personally identifying. And if it's not, if it's just statistics or trends or patterns, then that can be given out. And my number one kind of antidote there, to the extent that this works and nothing's foolproof, is you got to gather the other examples, right? You got to gather the other examples that kind of shame people to say, well, look, Texas, Minnesota and Illinois and New York are all giving this out. And look, I'll show you the data right here. How come you have an interpretation of federal law that doesn't square with the same federal law everywhere? How come you have an interpretation of federal law that doesn't square with what any other state is doing? And maybe you can shame them that way. At least you can show that, look, dozens and dozens of people are giving out this data and nobody's being punished for it. And if this was a HIPAA violation, we would know it by now because the feds would have stopped it.
Someone asked if we could share your contact information. We will send a follow-up email with that information, as well as some resources that were compiled by the panelists, as well as, if permission is granted, some of the information that's in the slides that were shared. Paul, in our closing moments here, I'd like to give each of you a chance to kind of give any closing thoughts. And this hour has gone quickly, and there's a lot of great questions that we didn't get a chance to get to, but hopefully those folks can reach out to you or find other ways through the information to seek out those answers. But Paul, any closing comments or thoughts, especially targeted towards journalists and how we can best navigate these waters?
I think, thanks, John, and thanks everybody for attending today. Thank you to my 2 friends and co-panelists here. This has been a lot of fun to put this together and then to have this hour. I would say reach out to us, keep pushing, don't give up.
Great. Kathryn, any closing thoughts do you like to give?
Cultures change, and sometimes cultures get very corrupt. I would say don't give up. Don't give in to the PR culture. Don't give in to as much stress as the news media is under right now. Don't give in up to just taking their handouts or whatever, because this is a corruption, and it's going to undermine us as a democracy. It is undermining us as a democracy, and it's abusive to people, and it's going to kill people. We don't know what is going on in the agencies that are supposed to serve us and supposed to protect us from things like pandemics. So no, do not give up.
Great. And Frank, any closing thoughts from your vantage point?
So John, I'm going to try to hit real quick in like 20 seconds each as many of these questions in the rail as I can, and then invite people to follow up. Somebody asked about how should journalists react when they're excluded from a press conference or a press event that's taking place on private property, like a shopping mall. Governor convenes a press conference in a shopping mall or a non-government-owned property. I mean, the answer is it's actually not very well established under the First Amendment that journalists have any, quote, First Amendment right to be in a place where news is happening. This is an issue that hasn't been litigated nearly enough, and it needs to be litigated more. Project for next year. That's a next step, is we need to establish clearly that there is a right to actually plant your feet where news is happening. I would say, to the extent that you were able to show that you were selectively excluded because of the viewpoint of your media organization, that is the strongest First Amendment case. And so if you're excluded for some other reason, well, we didn't have space for you, not a great First Amendment case. But if it looks like you were selectively singled singled out for differential access, then you got a First Amendment problem. Last one, somebody asked about, well, is this a problem at the local level as well as the national level? It is absolutely a problem at the local level, the national level. All levels of government are doing this PIO gatekeeping. I think one reason that the advocacy is focused on the federal level is that the physical access to the agencies is so bad there. The physical access to the agencies has become nil since 9/11 because of the security culture. It's still possible in a lot of places to walk into a sheriff's office and talk to people at the front desk without going through 6 metal detectors, but it's not at all possible to do that in a federal agency. And so I think that's one reason why the advocacy is focused on the federal level. But to be sure, SPJ is concerned, and we are at Brechner, about the folks that are covering those state and local agencies as well. So with that, just thanks to SPJ for this opportunity, and do follow up with all of our contact information. I appreciate that opportunity.
Thank you. We continue to track this issue, as was pointed out by Paul. I put the web link for spj.org where that particular information is held on our website, but feel free to go there, and we'll continue to keep on this issue, including several of the questions and insights that the attendees brought up. We will incorporate that into the continuation of our study on this issue. Thank you, panelists, for some excellent thoughts and insights. It's not going away as an issue, and it's something we'll stay on top of for sure. And thank you, attendees, for spending some time with us today. Good luck as you continue to work in this interesting environment we're in, and I wish you the best. We look forward to seeing you at a future webinar and some sort of a future event, whatever that may be. Thank you all.
Thank you.
Thank you.